The Fifth Circuit on Tuesday of this week upheld injunctions barring, this is crazy, barring the National Labor Relations Board from prosecuting unfair labor practice charges against three companies, saying the removal protections that federal labor law gives board members and agency judges likely violate the U.S. Constitution. So this is not just applying in Texas. This could have much broader implications. Three companies, including SpaceX, had sued to block the National Labor Relations Board cases against them based on what they characterized as unconstitutional limits on the president's ability to fire board members and administrative law judges. So, Jim, what does this mean for employers facing unfair labor practice charges in front of the National Labor Relations Board right now?
Yeah, I think it's a little early to tell right now. It certainly potentially cuts the legs out from underneath the board, right? And it's amazing to me that the NLRA has been around for 90 years. It had challenges to its constitutionality right from the get-go that survived. But it all goes back to this unitary theory of the executive, right? That SpaceX was sort of pushing a couple of years ago when they started this, and then President Trump has adopted. And so for the viewers out there, I think everybody understands that certain agencies, the State Department, Treasury Department, Department of Defense, those folks serve, who are in charge of those agencies, serve at the president's pleasure, right? So a new president comes in, we got a new Secretary of State, new Secretary of Defense. But then there's these other agencies that exist within the executive branch, like the NLRB, like the EEOC, like the Occupational Safety Health Review Commission, like the National Mediation Board, that are these sort of made up of multiple members. This violates the separation of powers. If these guys are in the executive branch, they should serve at the pleasure of the president, right? And you can't have all these like multiple layers of protection for removal of these folks, right? Because it would violate the separation of powers, right? It violates the president's authority to operate the executive branch. So it really sort of dovetails with this Wilcox case that you mentioned, Bert. Ultimately, I think that the Supreme Court, with the members anyway, with the board members, the Supreme Court is gonna decide that. I guess they're should chime in on the ALJs, but I don't know if the Supreme Court's gonna already say, hey, between SELA law and JARCASI, we've already sort of called into question the ALJ sort of format.